Hello, hello. Good morning, everyone. This is Yanira Mendoza, and we are at Hablemos de Relaciones y Divorcio, but today is going to be Let's Talk About Relationships and Divorce. And our guest today is attorney Julio Joglar. He's a local attorney. He's been um, a professional for almost 30 years, right? You've been practicing law in Houston.
Right.
Yes, and he was my former boss for almost 2 decades. So he's my mentor, my example, and a good friend. And thank you for being here today. We need to talk about divorces because a lot of people divorce. What is the hardest thing they have to do when they go see you?
Well, I guess from a general perspective, I think the biggest issue when people go through a divorce is emotions, the lack of control of their emotions.
Okay.
And that is something that, of course, we lawyers, that's not our cup of tea. We're not trained and we're not supposed to be involved emotionally in these divorces. But that's basically the hardest part. And that's why the role of an attorney, of a family law attorney, is so difficult because you got to do your job as a lawyer.
Yes.
And on top of that, you have to deal with this
Emotional clients.
these emotions and this amount of all kind of emotions up and down and anger and sadness and all kind of things. And good lawyers, good family lawyers learn to stay away from those emotions because they need to be practical and they need to focus on the case without getting involved emotionally into it. Once you do that, you lose your partiality and that can create problems for your client.
So when people think that you are not empathic to their pain, that's not true. You're just doing your job as being logical and practical.
Yeah, we hear that once in a while, somebody complaining, well, you know, you need to be more empathic, but we are empathic.
Yes.
And part of the job, what I suggest lawyers to do is just communicate with your client, explain to them, express to them that you're empathic and that you feel their pain and that you understand what they're going through, but that you must not get involved into their emotional war.
Right.
Because if you do that, then you cease to, or it's hard for you to do what you're supposed to do. And sometimes when I explain that to my clients, they understand and they understand that, hey, I just can't do it. If I do that for you, then you're going to have me as an emotional ally, but you're going to lose me as a lawyer. When you have to, and when it has to be done, then we're here to help you.
That's right. So what is the first step to take when someone wants a divorce?
Somebody wants a divorce, the very first step is to talk to a lawyer and just let the lawyer know that you are looking into getting a divorce and try to get a little bit of information as to what you should be doing before you file for divorce. Usually there's a period where people kind of debate whether they're going to get divorced or not. And that's a good time for you to talk to a lawyer to make sure that you start doing and taking steps that they will protect you and help you once you make that decision. Like, for example, how to save certain documents, how to make sure that you have certain information that you might need later on protected, how to avoid purchasing new real estate, new properties, or getting into a certain amount of debt right before you file for divorce. So it's always a good idea to talk to a lawyer and to ask him, hey, what should I do and what should I not do before I file for divorce?
That is great. So do we have to have a good reason to file for divorce?
No, you really don't. In the state of Texas, I mean, if you just don't want to be married, that's good enough reason. State of Texas doesn't require you to be stuck with someone that you don't want to be with. So you really don't need a reason other than just want to get divorced. That's it.
Right. So the basic reason is I don't want to be with you.
Pretty much. I mean, there's a legal term, insupportability, which is a conflict between personalities, but that's just the legal definition. But basically what it means is you guys don't get along. So it's time to get divorced.
So from your perspective, what is the cause number one of divorces? Why people file for divorce
Well,
usually?
it's hard for me to pinpoint exactly what is the main, but we see a lot of people that they get divorced because they just don't get along anymore. They grow old and they grow apart. There's, of course, adultery. Somebody find out that the other person was having an affair with somebody else. There is, of course, domestic abuse, domestic violence, which is, a reason that we see quite a bit. But the main reason people get divorced is just because they just don't get along anymore. That's a lot of fighting, a lot of yelling and screaming, and they just don't get along.
Right. So are there requirements here in Texas to get divorced?
There's a couple of requirements, yes, absolutely. But the most important requirement to get divorced here in Texas is you need to be a resident in the state of Texas. You have to be you have to reside in Texas at least 6 months prior to the filing of the divorce. And you also have to reside at least 90 days in the county where you file that divorce. That's the main jurisdictional requirement to file divorce here in Texas.
Okay. So somebody cannot come from another country and just get divorced and then leave.
No,
No.
not unless you have been here for 6 months and 3 months in the county that you file.
How about an immigration status? People have to have has to be a citizen or resident.
No, not really. No. I mean, as long as you have been a resident of the state of Texas for the required amount of time and a resident of that county for the required amount of time, you're good to go, whether you're a resident, whether you are undocumented, whether you're documented, whether you're a citizen, doesn't matter.
Perfect. So can you explain the divorce process? Walk us through the process.
Well, once you file for divorce, we basically take care of the process and we file the petition for divorce. Then the next step is to make sure that the other person is aware, is notified that you have filed a petition for divorce. And we do that by serve that person with process. Sometimes the person acknowledged that by signing a waiver of citation, that they waive citation or service of process. But you require that person is entitled to due process, and you have to make sure that person is aware that the divorce was filed. Once that happens, this person decides to hire an attorney, or they need to file an answer, and they have a certain amount of time to do that. And then after that, then we start the negotiation process, and we start doing discovery. Some cases require discovery. Some cases discovery is not needed. But the importance of discovery in some cases is to find out what the assets are, what the value of the assets is. And then once you do that, then you start putting your case together, and we, the lawyers, do that. We prepare inventories of all the assets that need to be divided. We require financial information so we can calculate child support and other things. And then most courts in the state of Texas now, they require you to go to mediation. So then we go to mediation and we try to work things out, the best we can. If we reach an agreement in mediation, then we prepare a final order and your case is done. If we don't reach an agreement in mediation, then we start getting ready to go to trial. We prepare all the exhibits and everything you need to go to trial. And then eventually we have a trial. But that's basically in a nutshell how the process works.
Okay. So what if the person that responds to the divorce doesn't want to get divorced? What happens?
Well, I have bad news for that person, because in the state of Texas, you don't want to be married to someone, you're going to get your divorce. I mean, that's just a fact. So we see that once in a while, someone doesn't want to get divorced and they try to put, blogs, and they try to create all kind of issues to avoid what's going to happen anyway. But
exactly.
my advice to people is, look, don't do that. If your spouse don't want to be married to you, it's going to happen sooner or later. So the more roadblocks and the more obstacles you place in front of the case, the more money you're going to end up spending. And in the end, you're going to get divorced, or she's going to get divorced. It's going to happen regardless. So
for those people that think that if they don't agree, the divorce won't happen, that is not true.
It's not true in Texas.
Okay. What can delay a divorce process?
One of the things that delay divorce process the most is the court. Okay. I mean, every court has their own criteria, their own rules, their own way of process cases. And sometimes some courts they move fast. Some courts, they move very slow. Okay. And a lot of people have problems with that. They call us and they say, I had a friend of mine who got divorced in 6 months. Why mine is taking a year? Well, yours taking a year because we went to mediation and you guys weren't able to reach an agreement, and we have to have a trial. And we're waiting for that day from the court. The court is going to let us know when is your trial date. We just can't show up and tell the judge, hey, try my case today. They have thousands of cases and we have to wait our turn. And unfortunately, some courts can get you a trial date in 8 months, and some courts take a year and a half before you get that trial date. So that is the main delay on cases, is just basically the trial court. And then the second one, of course, is lack of cooperation from clients. Some clients, hey, they do discovery, you need to bring me X and Y documents, and they take forever, or they don't bring you what is required from them to produce. And that just create all kind of problems and all kind of delays. So those are what I see as the main two causes of delays.
Right. And also I remember working for you that some of our clients, they wanted to try one more time to get together with the husband, and then a baby will come. And that will put a stop to the divorce process.
Yeah. Sometimes that happens. And sometimes if one of the spouses, somebody's pregnant, then we have to wait until the baby is born before we can finalize the divorce.
Why is that?
Because it's just Texas law. Texas law requires that, the children be born before the judge, because in the state of Texas, you need to do the divorce and take care of the issues related to the conservatorship and the support of your children at the same time. You just can't divorce and put the children issues to the side. You have to do it at the same time. Okay. And we cannot calculate and we cannot do certain things unless the baby's born. So,
yeah. So should a person be concerned when the respondent doesn't want to sign the divorce and say, I'm going to send you the police guy to your work and stuff like that? You know how they...
No.
Okay, so tell us how that process works. That sending an officer to serve you the papers, they shouldn't be afraid. That's part of the process of the divorce.
Yeah, they shouldn't be afraid. Usually we don't use at my office, we don't use police officers. We use a private process server. Yes. Use somebody who's just going to go and give you the paperwork. But yeah, some attorneys, and that's okay. Some attorneys, they use constables and police officers, and their job is not to arrest you or harass you or do anything like that. It's just simply to deliver to you the paperwork, to let you know that you have been sued for divorce. That's it. It's just part of the process, and there's nothing to be afraid or concerned.
Yes, I have had a lot of people that, they say, he's going to send me the police at work. I'm like, no, he's probably going to serve you. Yes. They're going to serve you the papers. And then another thing that I hear a lot is that they want me to sign those papers that the processor is bringing. Is that correct?
Yeah, some process servers, they ask you to sign kind of a receipt that you have been served, but most of them, they don't. Okay. And the law doesn't require it. So if you have concerns and you don't know what you're signing, my advice to you is don't sign anything. Just accept service. Have a good day, sir. That's it.
That's it. Yes. So that way they don't feel like they probably signed something that they shouldn't have.
That's right. That's right.
That's a good way to put it. So what happens after someone gets served? What's the process after that?
After you are served, you have a very narrow window to respond to that lawsuit. So my advice is go and see a lawyer immediately. Don't put the papers on the kitchen table
Yeah.
and tell
Forget about
yourself,
him.
well, I talk to a lawyer next month. Don't do
Yes.
that. Go and make an appointment that day, because you have a very narrow window where if you don't answer to that lawsuit, the other side can get a judgment against you, what we call a default judgment, because you failed to answer on time.
Okay.
So it's very important that you see a lawyer right away.
That's interesting. So a lot of people don't even read the papers. So the
Mhm.
first page tells you how many days you have to answer.
Right. In the citation, they tell you usually, basically in the state of Texas, you have to respond, on before 9 o'clock on the Monday following the expiration of 20 days for the
Okay.
first Monday after 20 days. So you have about, if you kind of add the days, you probably, the best is about 27 days. The worst is about 21 days. So it's not a lot. It's not a long
Weekends
time.
count on those
They do.
days? They do? Okay.
They do.
So
So
got to pay attention. So you only have certain days to
right, they do.
answer.
So yeah, you need to see a lawyer right away.
Okay, good. Some divorces require temporary orders.
Some of them, yes.
So what instances do you suggest for somebody to have temporary orders on their divorce?
Well, it depends the situation. Most of the time, the purpose of temporary orders is to provide some temporary relief while the lawsuit proceeds. Like we talked before, some divorces can take a year, and obviously some people can wait a year to get some, for example, economic help from the other spouse, or to get some peace and tranquility in their lives. So that's when temporary orders come in.
Okay.
For example, couple, they're fighting and they just can't be in the same roof, and there's some domestic violence where somebody has to move out.
Okay.
So we ask the court for temporary orders to get somebody to move out, to pay child support, to pay certain bills. For example, when a spouse is unemployed and can't afford to pay the house bills, well, then we ask for some temporary spousal maintenance for the other spouse to pay the bills while the divorce is, during the process of the divorce. And that's basically one of the main reasons that we ask for temporary orders, is just to split the spouses and to take care of the bills.
Those temporary orders also contain restraining orders, right?
Yeah, the temporary orders usually have what we call temporary restraining order. And the temporary restraining order are basically some injunctions that prohibit the parties to do certain things or during the process of the divorce. But
what things, like, give me an example of those things.
Like, for example, both parties are enjoined from selling property.
Okay.
We don't want you to go and during the process of the divorce to go and
Go
start
crazy
selling
selling
stuff.
everything.
Yeah, we don't want you to do that. The other is, for example, injunctions against harassing the other party or calling them and making threats and stuff like that. We want to preserve the peace and make sure that everybody's calm and everybody's well behaved while we, the lawyers, do the job that we do. There's also temporary injunctions for the children. We want to make sure that you don't grab the kids and then suddenly disappear to Alaska. And then, there's certain things, rules, so the parties can behave during the process of the divorce. So.
Okay. So a lot of people confuse the restraining order with a protective order.
Right.
So can you tell us the difference between a restraining order and a protective order?
Sure. So in the state of Texas, we have restraining order and protective order. In some other states, they have a restraining order, which is the same as what we call a protective order, and that creates a lot of confusion. A lot of people tell me, well, I just got served with a restraining order. I don't know why. I haven't done anything wrong. Well, a restraining order is a tool that the court uses. It's not because you did something wrong. It's just basically a restraining order is something that is used and applies to both parties to prevent certain behavior and to maintain the peace and tranquility during the process of the divorce. A protective order is a whole different thing. A protective order is an order when the court finds that there has been some domestic violence or where one spouse is in danger, they issue a protective order. And that basically what it means is that the person is not allowed to come close to you, or it's a whole different thing, and it's meant to protect one of the spouses from future domestic violence. And violation of that protective order is a criminal offense versus a restraining order is not really a criminal offense. It's more a violation of a court order. And then you can be punished by the judges, by the court for violating those temporary injunctions. But a protective order is meant to provide some protection, but that's what it's called, protective against domestic violence and to keep you away from violent people.
Right. Okay. So you also mentioned on the process of divorce, mediation. What is mediation?
Mediation is a process where you have a neutral person and that person helps you to negotiate solutions to the issues that you have pending in front of the court. It is required by the court, but you're not required to reach an agreement. The mediator is not a judge. He's not going to go and tell you, hey, you have to do this, you have to do that. He's just simply there to try to help you guys to negotiate some sort of agreement so you don't have to spend more money on attorneys and you don't have to go in front of the judge. So that's basically what mediation is. It's just an attempt to work things out in a mutually beneficial way. Because remember, when you go in front of the judge, the judge is going to tell you what you're going to do.
It is what it is.
It is what it is, whether you like it or not. And it's very common, people going in front of the judge and both sides coming out of court upset because they didn't get what they wanted to. So the system wants you to take charge of your own life, to take charge of your marriage, and to try to work things out like two adults. And most of the time, people are able to work things out through mediation. Sometimes they can, and that's what the judge is there for.
Yes. And sometimes it's even better to reach an agreement at mediation because you can get anything you want if the other party is in agreement, right?
Most of the time, it's better to reach things, to work out an agreement through mediation. Yeah. Statistics have shown through the years that agreements reached through mediation, people end up more satisfied that orders received or judgment received from the court. They also tend to last longer, and in the end, they tend to serve better the parties.
So at a mediation, if one of the parties tells you, okay, you keep the house, so somebody gets like probably an 80% of, whatever it's assumed to be 50-50. The judge doesn't have any saying on that if you decide to give the house to your spouse?
Yeah, in the state of Texas, mediated settlement agreements are respected by the system. So when parties reach an agreement in mediation, and typically judges, they step aside and they basically tell you that's what you want to do. I'll respect your agreement, and you're entitled to a final judgment on that mediated settlement agreement, especially when it comes to property division.
So basically, mediation, it's better than going to trial. Well, in some instances, of course.
I think so. I think that mediation is always good. Yeah, it's always a better choice. Of course, sometimes you need two to tango. And if the other side doesn't want to reach an agreement, you have to go in front of the judge. But it's ideal if people can go to mediation and they can resolve all the issues through mediation.
Good. So can a man win custody of his children?
Absolutely. Absolutely happens all the time.
Okay. So because there's a myth that, men cannot get custody of the kids and stuff like that, but they can, obviously.
Absolutely. It's a myth. Like you say, it's a big myth.
Yes.
Yeah.
So can a spouse receive economic support during the divorce process?
Yeah. Absolutely.
How does that work?
Well, that's where temporary orders come in, and that's what you require from the court, you ask the court for temporary orders, and you request from the judge for some temporary support. And basically, one of the duties and responsibilities of the judge during a divorce is to protect the marital assets. And if the judge sees that one spouse is unemployed and doesn't have the capacity or doesn't have the means to pay for that asset, the judge can order the other side to, while the divorce is pending, order that side to pay for the house or for certain bills until the other spouse are able to get back on her feet and, find some economic assistance on her own.
Does everybody qualifies for that situation?
Well, yeah, I mean, it's not a matter of qualification. It's just a matter of looking at the evidence and the judge trying to protect and preserve the marital assets. And, the discretion of the court during temporary orders is broad. So, during temporary orders, the judge can order anybody to pay anything versus when the divorce is final.
Okay.
That's a whole different
That was
a whole different story.
That was my next question. How about after the divorce?
Now, after the divorce, that's a whole different question. And then the qualifications for some post-divorce spousal maintenance, they're very difficult, and they're more there are more rules and more things that you have to do to qualify for some spousal support after the divorce.
So what are some of those qualifications? What do we need?
Well, the most important qualification is to show that you have attempted to look for employment to be able to pay for your minimum financial needs. And that's something that a lot of lawyers, sometimes they kind of ignore. They forget to tell the clients. They usually jump and they tell them, well, you have to be married for 10 years and you have to do this and that. But they forget that you first need to rebut that presumption in the Texas Family Code that you're not entitled to spousal support. And that presumption is rebutted by showing that you have looked for employment and you just can't find a job to meet your minimum financial needs. And then after you're able to rebut that, then you can move, and then you can see, you can go back and look to other requirements like the 10 years or the history of domestic violence or having somebody incapacitated that you have to support, and it prevents you from getting a full-time job, or you are incapacitated yourself, and so forth.
Okay. So when you say incapacitated, there's some children that they declare with disabilities, right?
Right.
So I always have this question. Those kids receive child support until they're 18, or they can go past the 18?
Yeah, it depends. But yeah, sometimes children under Texas statute are entitled to receive child support past 18.
Okay.
Yeah.
Good. So I always wanted to know what is the difference between a spousal support and alimony?
Well, yeah. In the state of Texas, we don't have alimony. We have spousal support. And that's just the name that the legislature in the state of Texas decide to call decided to call it spousal maintenance. And some people argue that spousal maintenance and alimony is the same. Some people argue where it's different. In some states, they have alimony, in California, Florida. But here we call alimony, we call it spousal maintenance.
Okay.
Yeah.
So going back to the person who files for divorce, it's been a homemaker for, let's say, 20 years or 10 years, whatever. So the best thing for them to do is to start looking for a job while the divorce is in process. So when you go to trial, you have proof that you have been applying, that you have been trying to get a job that covers the minimum.
Yeah, exactly. Yeah, you have to show evidence that you have actively searched for employment, find a job to meet your minimum financial needs.
And what it's minimum financial? What that covers?
Yeah. Well, you have to show the court that you were looking for employment to be able to pay your minimum bills.
Okay.
Meaning that, okay, I look for a job to pay my rent, my electricity, my bills, and we're not able to find anything like that. It doesn't mean like some people, well, I look for a job and I want to make $100,000 a year, but nobody wants to pay me $100,000 a year, so I'm not going to work. It doesn't work like that. So.
Okay. So what do you tell to these people who file their own divorce? Because that's a very popular thing.
I tell people that if you don't have any children and you don't have any property, you might get away with it.
Okay.
Okay. The law keeps changing, and family law in the state of Texas every year keeps getting more and more and more complicated. 25 years ago, when I was a new lawyer, I saw a lot of people doing divorces on their own. And they were able to get away with it. But in the last 25 years, the changes, they're just too great. And if you have children or if you have property that you need to divide, my advice to you is don't try to do it on your own.
Yes.
Because it's not going to work. And even if you're able to save some money and you're able to do it, you can have negative consequences later on. Like I have seen a lot of people who do a divorce on their own and they go and they get child support in the order and they're happy because they were able to do it without a lawyer and they save a lot of money. And then suddenly husband decide not to pay child support. And then they go to court and they try to enforce the child support, but because they did the divorce decree on their own, they used the wrong language. They didn't add it was required to make the order enforceable, and they cannot enforce the order. I've seen that happening, and I seen later down the road, I see a lot of mistakes in the preparation of the final decree of divorce, and the money that you save originally, eventually you end up paying twice as much
to fix
the mistakes, to fix the errors. And again, I don't recommend that to people.
Right.
And
I tell my clients, a divorce with no children is 3 pages long.
Right.
A divorce with children is 40 or sometimes 50 pages long.
Right. Especially if you have property.
Yes.
It's a long decree of divorce.
And you have to know what you're doing.
And the judge will sign it. The judge will sign it. And, but it's on you later on down the road.
Well, I remember working for you that when people did that, the judge will say, it's not right, go fix it. But they won't tell you what is wrong.
Right.
So that's important to have an attorney to tell you, okay, you messed up here, you did this. Or just hire an attorney to do a final decree of divorce. That will be another solution.
Yeah. The judge cannot give you legal advice.
Right.
So if the judge looks at the final decree of divorce, and in the final decree of divorce, there is some information that is missing that is required by the law, the judge is not going to approve the divorce.
Okay.
But once you put that information there, the judge will approve the divorce. Now, if that information later on is wrong, that's on you.
Yes.
But, again, the judge cannot give you legal advice and tell you, you know what, I'm going to sign this decree of divorce. But by the way, this order is not enforceable. If later on you want to punish the other side, ask for punishment for not paying you child support, it's not going to happen.
Right.
So
the divorce also includes health insurance, and that's mandatory, right? Because a lot of people don't know that.
Yes.
Whoever pays child support also is obligated to
provide medical and dental health insurance.
Okay. So that's for everybody. There's no exceptions because a lot of people don't know this information. So it's important for them to know.
Yeah, judges wants to see, and they require, and the order needs to take care of that issue, especially when they're children. They need to have health insurance and dental insurance for the children, and the judges want to see that in the order. Now, of course, if you go to mediation, you're able to work things out, and maybe the obligor, which is the person who pays child support, is required to provide health insurance, but sometimes the other spouse, the obligee, is able to do it cheaper through her employer, and that's okay. We can work those agreements. Sometimes nobody have money to pay for health
Private
insurance.
insurance,
So we can put in the order that you need to apply for Medicaid or CHIPS or any of these government programs. But yeah, we have to take care of that during the divorce, and we have to make sure that the order includes language for medical and dental support for the children.
Okay, good. So do you offer free consultations?
Yeah. In our office, the initial 30-minute consultation is free.
Okay.
So if you have any questions, feel free to contact us. And
I know we have your phone number on the screen, but can you tell us your phone number at the office?
it's 713-787-0191.
Okay. So it seems like we have the wrong number in there, but we'll fix it and we'll tell us again your phone number at the office.
713-787-0191.
0191. Okay.
Mhm.
And this consultation, it's 30 minutes long.
Right.
Okay. So when somebody goes to your office, it's expected for them to ask you legal questions, but mainly they go with the emotional baggage and they start telling you things that they have nothing to do with the legal side of the divorce. So what questions are those that they need to ask? So those 30 minutes can be, what you call it? Well distributed.
Yeah. Well, again, we understand the emotional implication of divorces. I mean, as a family law lawyer, you wouldn't be in this business for that long of a time if you weren't able to or understand the emotions. So what I try to do is I try to guide people.
Okay.
And as soon as they start getting into the emotional things of the divorce and to complain and everything, I mean, I want to hear a little bit, obviously, and I want to try to understand what is the cause of the divorce, because I need to hear if there's some domestic violence, if there, but if the person start going into a narrative and everything, then I try to guide the person. Okay, let me ask you something. What kind of property you guys have? How old are your children? Do you guys have agreements after the children issues or not? And I try to guide the people. But mainly when people come to me, just be ready with information about your property.
Yeah. What about the financial?
The financials, just ask questions about your children, the ages of your children, any child under the age of 18, if there's some disabilities, if there's something that you believe you will require some assistance long-term for this child. And just simply know how much. For example, one question I get all the time is, I ask people, you have a house? Yes. And how much you own the house? I don't know.
Yeah. I've heard that many times.
Yes. It's good for your lawyer to know how much you owe, because the value of the house minus the debt equals the equity. And the equity is what the judge is going to divide. And later on, we can discover that and find that out. But if you have a question based on that, then it's good to have that information right away.
Also, one of the most popular questions is, how much child support am I going to get?
Right. And that's another good question, that if you want me to give you an answer right away, then have that information. Tell me how much your husband makes.
Or if you have check stubs, bring the check stubs.
I ask people, so how much you believe your husband makes? I don't know. Okay, well, how much last year taxes, how much he reported? I don't know.
I don't know. Yes.
Okay. Well, again, we can discover that later on, but you need to understand that I won't be able to give you an answer right away.
Right.
We're going to have to do discovery and do some work later on. But if you want an answer to your question right away, you need to have that information.
Yes. So you need to prepare. You need to do your homework. So let's make sure you have all those financial statements ready to go.
Taxes,
when you
if you have taxes for last year, that helps a lot.
That helps a lot. Well, and I think we have gotten to the end of our show. Thank you so much, Mr. Joglar, for coming in today.
My pleasure.
And tell us where people can find you. They can make an appointment and they go see you for a free 30-minute consultation.
Yeah, just give us a call. Give us a call and we will schedule you for a consultation, and we can do it in person. We can do it via FaceTime or Zoom.
Nice. Okay.
If you don't want to drive all the way down, and we'll talk to you.
Okay, remember the number is 713-787-0191. And if you need a good and excellent divorce coach, well, I'm here for you. My number is 713-884-0718. And we'll see you next Tuesday in Hablemos de Relaciones y Divorcio.